Okay, so hello and welcome to Atentive's webinar. Today we're going to be presenting on the HITECH Security and Hipaa Act. This is our fifth and final webinar in our Government Regulations and Ramifications series. My name is Chelsea Grover and I'm the Marketing Communications Coordinator for Attentive. I'd like to take a moment to explain the process for today's presentation. First, I'd like to mention that this webinar will be recorded. Next, I'd like to remind you that recordings and slides from all of our previous webinars, including previous 3 in our Government Regulations and Ramifications series, are available on our website under the Events and Education section. Finally, I'm pleased to announce our upcoming webinar, Immunizations A to Z, Administration to Z23. In this webinar, we're going to walk through all aspects of immunization, including building and maintaining your inventory, VFC versus private, ordering, administration, and billing. Join us for this webinar to brush up on your immunization knowledge. It's going to be on Wednesday, January 20th at 12 p.m. Central Time. Keep your eyes out for the webinar invitation from us or follow us on social media to see the announcements. Okay, so back to HITECH and Hipaa. At the end of the presentation, we're going to open the floor up to questions from you. We will answer all the questions at the end, but you may type them in the questions area of the webinar control panel whenever they occur to you. For your reference, we will also be emailing links to the recordings and PDF of the presentation later this week, as we do with every webinar. Finally, for audio clarity purposes, everyone's phone will remain muted throughout the entire webinar. If you experience audio issues, please use the chat box to let us know so we can resolve them. And again, questions may be entered in the questions box. As we mentioned in the webinar invitation, we're planning on today's webinar running roughly an hour and 15 minutes due to the detailed subject matter and have set aside time at the end to answer questions. If you have to leave before we're finished, you can always catch the end of the presentation on our website. So without further delay, I'd like to introduce our presenters for today, Lindsay Lanning and Cindy Kincaid. Lindsay Lanning originally joined us from the Ohio State University intern program while she was getting her degree in Health Information Management Systems. After graduation, Lindsay joined our team as the Healthcare Informatics Coordinator, where she spends her time immersing herself in the ever-changing healthcare IT environment and educating the rest of the company on new issues and trends in the industry. Lindsay will be leading today's webinar. Cindy Kincaid is Vice President of Consulting Services at Attentive and a Certified Practice Management Executive. With over 25 years in the IT healthcare industry and 9 years with Attentive, I think it's fair to call her a subject matter expert in everything next-gen. She has had the honor to speak at many MGMA and next-gen user group meetings in the past. Okay, so Lindsay, I'm going to go ahead and pass the webinar off to you. Feel free to get started when you're ready.
Great, thank you, Chelsea. Hi, everyone, and thank you for joining us today on our webinar regarding Hipaa and HITECH. These are both pieces of legislation I'm sure everyone is at the very least familiar with, but a lot of times the details and requirements laid out in these laws are often skimmed over. These laws are put in place to address the privacy and security of personal health information. We all know maintaining the security of patient data is a complex proposition that affects every employee of a healthcare facility, every area of its IT system, and all vendors, partners, and insurers that work with the healthcare provider. This is why we at Attentive thought it was so important to go over the details of what is expected from you and your practice in regards to Hipaa and HITECH requirements. So in today's webinar, we will start by breaking down Hipaa and covering the basic foundational information before we dive deeper and cover the Hipaa privacy and security rule in great detail. Then we will move on to the 2 most recent pieces of legislation to make changes to Hipaa, which are the HITECH Act and the Omnibus rule. And then finally, we will wrap this presentation up with how these rules and regulations affect you, covering best practices to pass an audit and prevent a data breach. So let's start by breaking down Hipaa. So the Health Insurance Portability and Accountability Act, or HIPAA, was enacted by the U.S. Congress on August 21st, 1996. HIPAA protects health insurance coverage for workers and their families when they change or lose their jobs, requires the establishment of national standards for electronic healthcare transactions, and requires establishment of national identifiers for providers, health insurance plans, and employers. HIPAA is a mandatory federal law, preempted only by more stringent state laws. Historically, confidentiality legislation was a patchwork of state laws with some overlying federal legislation. Some states offered greater protection to patient information than others, but in the 1990s there was a strong push for federal legislation to uniformly protect health information. So HIPAA protects the privacy and security of patients' health information by regulating access and providing electronic and physical security safeguards to protect a patient's health information. It also gives individuals more control over their protected health information and more individual rights. And finally, it also increases the federal government's enforcement authority over fraud and abuse in the healthcare arena. The Act is massive in scope with 5 separate titles, which we will go over now. So like I said, HIPAA has 5 main parts, and they're called titles, the first being portability. Portability allows individuals to carry their health insurance from one job to another so that they do not have a lapse in coverage. It also restricts health plans from imposing pre-existing condition limitations on individuals who switch from one health plan to another. Title II, Administrative Simplification, requires the establishment of national standards for electronic healthcare transactions and national identifiers for providers, health insurance plans, and employers. The administrative simplification provisions also address the security and privacy of health data. So under this title is where the privacy and security rule both reside, which we will go into much greater detail on. So then Title III is on medical savings account provisions. Title IV is the application and enforcement of group health plan requirements. And Title V contains information on additional revisions to the Internal Revenue Code. So there isn't too much to know from these titles. I just wanted you to know that there were 5 titles. And Title II, Administrative Simplification, is what we will be focusing on from here on out. So Title II of HIPAA, known as the Administrative Simplification, requires the establishment of national standards and addresses the security and privacy of health data. The standards are meant to improve the efficiency and effectiveness of the nation's healthcare system by encouraging the widespread use of electronic data interchange. So the administrative simplification rules are the HIPAA privacy rule, the HIPAA security rule, and then a group of 3 rules that can be lumped together under electronic data interchange, which are the transactions and code sets rule, national provider identifier rule, and the employer identifier standard rule. And then I also included this organizational chart just as a visual breakdown of HIPAA to better understand where we are as we progress through this webinar. So you can see the 5 titles under HIPAA, and then privacy and security as branches off that Title II. Specifically, the 2 parts of HIPAA we will be covering in this presentation are the HIPAA privacy and HIPAA security rule. HIPAA privacy addresses the protection for the privacy of protected health information effective April 14, 2003, and HIPAA security addresses the protection for the security of electronic protected health information, or EPHI, effective April 20, 2005. So these 2 rules came about because there was a provision found in HIPAA that required the HHS to adopt national standards for electronic healthcare transactions and code sets, unique health identifiers, and security. At the same time, Congress recognized that advances in electronic technology could erode the privacy of health information. Consequently, Congress incorporated into HIPAA provisions that mandated the adoption of federal privacy protections from individually identifiable health information. And to clear up any confusion early on, yes, there is a difference between privacy and security. They are 2 separate rules found under HIPAA. So when a vendor, a business partner, or a colleague implies that they are HIPAA compliant, the first question you should ask, now that you know, is under what rule? That will quickly tell you whether or not they truly know what they're talking about. Most of the time when someone says that they're HIPAA compliant, they're referring to the privacy rule requirements, but compliance with both rules is required. Now let's look at the difference between privacy and security. The HIPAA privacy rule describes what information is protected and how protected information can be used and disclosed, versus the HIPAA security rule, which describes what safeguards must be in place to ensure appropriate protection of electronic protected health information. Notice I highlighted electronic. I did this because the privacy rule applies to PHI in all mediums, and the security rule is strictly for electronic PHI. The privacy rule really answers the questions what PHI is and how it can be used, whereas the security rule answers the question, how must I protect ePHI? So let's start by looking at the privacy rule. The standards for privacy of individually identifiable health information, the full name of the privacy rule, establishes for the first time a set of national standards for the protection of certain health information. The privacy rule standards address the use and disclosure of individuals' health information, called protected health information, or PHI, by organizations subject to the privacy rule called covered entities, or CEs, as well as standards for individuals' privacy rights to understand and control how their information is used. Within HHS, the Office for Civil Rights, or OCR, has the responsibility for implementing and enforcing the privacy rule with respect to voluntary compliance activities and civil money penalties. A major goal of the privacy rule is to assure that individuals' health information is properly protected while allowing the flow of health information needed to provide and promote high-quality health care. The rule really strikes a balance that permits important uses of information while protecting the privacy of people who seek care and healing. Given that the healthcare marketplace is diverse, the rule is designed to be flexible and comprehensive to cover the variety of uses and disclosures that need to be addressed. So what does the HIPAA privacy rule really do? Well, it gives patients more control over their health information, its use, disclosure, content, and access. And it truly gives patients a greater voice in individual rights. There are two pods of the HIPAA privacy rule, access and patient rights. This rule gives patients greater access to their record and at the same time limiting it for others. And it also gives increased rights to the patient, giving them more control over their own information. So let's start with the basics. Who does HIPAA apply to? The answer is covered entities and their business associates. You are considered a covered entity if you are a healthcare provider, a health plan, or a healthcare clearinghouse. And once you are considered a covered entity, HIPAA applies to all PHI, whether it is transmitted electronically, in paper format, or transmitted orally. So who is considered a business associate? Under HIPAA in general, a business associate is a person or organization other than a member of a covered entity's workforce that performs certain functions or activities on behalf of or provides certain services to a covered entity that involves the use or disclosure of individually identifiable health information. You can see the HIPAA definition of a business associate is very broad and includes partners that may provide legal, accounting, consulting, data aggregation, management, administrative, or financial services wherein the services require the disclosure of PHI. The critical aspect of the business associate concept is that the HIPAA privacy rule mandates that providers have written contracts with them, and that's each of them. Business associate agreements is what they're called. So let's talk a little bit more about business associate agreements. When a covered entity uses a contractor or other non-workforce member to perform business associate services or activities, the rule requires that the covered entity includes certain protections for the information in a business associate agreement. So don't forget, no business associate agreement means non-compliance. Now we know who HIPAA covers, let's into the question of what it covers. And that's protected health information, or PHI, which can be defined as individually identifiable health information that relates to an individual's past, present, or future physical or mental health condition, provision of health care and or payment for the provision of health care, and that is held or transmitted by a CE or a BA in any form or media. This is very specific, but does cover a large range of information. Because keep in mind, the HIPAA definition of health information means any PHI recorded in any form or medium. So that's electronic, paper, or oral. Let's quickly revisit the term individually identifiable health information. Some examples of this would be a patient's name, date of birth, admission date, discharge date, date of death, all ages if you're over the age of 89, and even a person's geographic subdivision if it's less than 20,000 people. This is so strict because there are no restrictions on the use or disclosure of de-identified health information. De-identified health information neither identifies nor provides a reasonable basis to identify an individual. And because it is not considered PHI, it is not covered by the HIPAA privacy rule. So here are some more examples of individually identifiable information that could be considered PHI and is protected by HIPAA. So you see things here like telephone numbers, fax numbers, email addresses, obviously social security numbers and medical record numbers, but you also have vehicle identifiers and serial numbers, including license plates, and even the name of someone's employer. Now that we know the who and the what, let's look at the why, or the purpose. A major purpose of the privacy rule is to define and limit the circumstances in which an individual's protected health information may be used or disclosed by covered entities. In order to fully understand how it does this, we will first define what use and disclosure mean, and then look at authorized and permitted uses and disclosures. So the Hipaa definition of disclosure means the release, transfer, provision of, access to, or divulging in any other manner of information outside the entity holding the information. So think of just sharing it. And the Hipaa definition of use means, with respect to individually identifiable health information, the sharing, employment, application, utilization, examination, or analysis of such information within an entity that maintains such information. A covered entity may not use or disclose protected health information except either as the privacy rule permits or requires, or as the individual who is the subject of the information authorizes in writing. So we have these authorized uses and disclosures. So a covered entity must obtain the individual's written authorization for any use or disclosure of protected health information that is not for treatment, payment, or operations, or otherwise permitted or required by the privacy rule. All authorizations must be in plain language and contain specific information regarding the information to be disclosed or used. The persons disclosing the information, people receiving the information, the expiration date, and the right to revoke in writing, and other data as well. Basically, what these authorization forms need to do is describe the PHI being used and identify who may use it or receive it, and the purpose for the use of disclosure. This needs to be signed by the patient or their personal representative and have an expiration date. Bottom line is that you need a signed authorization form from a patient if you plan to use or disclose PHI unless it falls under a permitted use or disclosure specified by the privacy rule. So what are these permitted uses and disclosures? A covered entity is permitted, but not required, to use and disclose protected health information without an individual's authorization for the following purposes or situations. So these are essentially the exceptions to needing a signed authorization from a patient. And we will go through the ones that are likely to affect your practice, which are to the individual. So a covered entity may disclose protected health information to the individual who's the subject of the information. For uses and disclosures with opportunity to agree or object. So informal permission may be obtained by asking the individual outright or by circumstances that clearly give the individual the opportunity to agree or object. So examples of where this permitted use or disclosure is seen most is with facility directories and notification purposes. So if we look at facility directories, it's a common practice in many healthcare facilities and hospitals to maintain a directory of patient contact information. So a covered healthcare provider may rely on an individual's informal permission to list itself in the facility directory. They can list the individual's name, general condition, and location in the facility. The provider may then disclose the individual's condition and location in the facility to anyone that asks for them by name. And then the other reason for notification and other purposes, a covered entity may rely on the individual's informal permission to use or disclose PHI for the purpose of notifying family members, personal representatives, or others responsible for the individual's care. This provision, for example, allows a pharmacist to dispense a filled prescription to a person acting on behalf of a patient. Next, we have incidental use and disclosure. This kind of acts as a safety net and basically means a use or disclosure liable to happen as a consequence of an otherwise permitted use or disclosure. An example of this would be placing a whiteboard in each nurse's station with the last names of the patients on the units and the nurses that are assigned to each patient. So here the nurses are using the patient's PHI without getting the patient's authorization to be put on the board, but it's allowed under this permitted use. And we have public interest and benefit activities. So the privacy rule permits use and disclosure of PHI without authorization for 12 national priority purposes. Specific conditions or limitations apply to each public interest purpose, striking the balance between the individual privacy interest and the public interest need for this information. So just a few of these are if the information is required by law for law enforcement purposes or judicial proceedings, if it's required for public health activities, if it regards victims of abuse, neglect, or domestic violence, if it involves organ donation information, is a serious threat to health or safety, and lastly, workers' compensation. And then the last permitted use and disclosure that we're going to go over is TPO, which will actually go into more details on the next slide. So TPO, covered entities may use and disclose PHI without consent for TPO, and that stands for treatment, payment, and operations. So treatment means the provision, coordination, or management of healthcare and related services by one or more healthcare providers, including consultations and referrals. Payment refers to activities by a healthcare provider to obtain payment or to be reimbursed for the provision of healthcare. And operations refers to routine operation of the healthcare organization, which includes medical reviews and audits, legal services, business planning, and development. So for all other uses and disclosures of PHI not covered by the permitted uses we just went over, the CE must get assigned authorization from the patient. Switching gears a little bit, we're going to focus on a central aspect of the privacy rule, which is the principle of minimum necessary. A covered entity must make reasonable efforts to use, disclose, and request only the minimum amount of protected health information necessary to accomplish the intended purpose of the use, disclosure, or request. A covered entity must develop and implement policies and procedures to reasonably limit uses and disclosures to the minimum necessary. When the minimum necessary standard applies, a covered entity may not use, disclose, or request the entire medical record for a particular purpose, unless it can specifically justify that the whole record is actually needed. Bottom line, people should only have access to PHI that is necessary for them to do their jobs. So the minimum necessary standard applies to both the use and disclosure of PHI and must follow certain policies and procedures to be in compliance. The first is access and use. For internal uses, a covered entity must develop and implement policies and procedures that restrict access and use of PHI based on the specific roles of the members of their workforce. These policies and procedures must identify the persons in the workforce who need access to PHI to carry out their duties, the categories of PHI to which access is needed, and any conditions under which they need the information to do their jobs. Then for disclosures and requests for disclosures, covered entities must establish and implement policies and procedures for routine, recurring disclosures that limits the PHI disclosed to the minimum necessary. Individual review of each disclosure is not required. For non-routine and non-reoccurring disclosures, covered entities must create criteria to limit PHI disclosure to the amount reasonably needed to accomplish the purpose, and they do need to review each of these requests individually. So this reasonable reliance. This means if another covered entity makes a request for PHI, a covered entity may rely on the request as complying with the minimum necessary standard. So a covered entity may also assume the same reasonable reliance for a public official, a professional who is the covered entity's business associate, or a researcher who provides the documentation required by the privacy rule for research. So we're now aware of the authorized and permitted uses and disclosures of PHI that must follow the minimum necessary requirements. But oftentimes, patients are unaware of the many uses of their health information and how many people access it. So HIPAA requires each covered entity to provide a notice of its privacy practices. The privacy rule requires that the notice contains certain elements. The notice must describe the ways in which the covered entity may use and disclose PHI. It must state the covered entity's duty to protect privacy, provide a notice of privacy practices, and abide by the terms of the current notice. It must describe the individual's rights, including the right to complain to HHS and to the covered entity if they believe their privacy rights have been violated. And finally, the notice must include a point of contact for further information and for making complaints to the covered entity. HIPAA also requires that CEs request every patient to sign a written acknowledgement that they have received the notice of privacy practices. And this is called an acknowledgement of notice receipt. A covered healthcare provider with a direct treatment relationship with individuals must make a good faith effort to obtain written acknowledgement from patients that they received the privacy practices notice. The privacy rule does not prescribe any particular content for the acknowledgement, but does specify the provider must document the reason for any failure to obtain the patient's written acknowledgement. So those patient rights I mentioned that must be included in the Notice of Privacy Practices are the 5 listed on the slide. There are certain exceptions and detailed explanations that go along with each, but I just want you to know what they are, be aware of them, and I'm not going to go into all the details for the sake of time. So the first is the right to access patient's PHI, the right to request amendments to the information, the right to an accounting of disclosures of PHI, the right to request restriction of PHI, and the last right is to request confidential communications. So who enforces all of these requirements, and what happens if I'm not in compliance with these requests? Well, the Department of Health and Human Services Office for Civil Rights is responsible for administering and enforcing these standards and may conduct complaint investigations and compliance reviews. Covered entities that fail to comply voluntarily with the standards may be subject to civil money penalties. In addition, certain violations of the privacy rule may be subject to criminal prosecution. OCR may impose a penalty on a covered entity for failure to comply with the requirement of the privacy rule. Penalties will vary significantly depending on factors such as the date of the violation, whether the CE knew or should have known of the failure to comply, or whether the covered entity's failure to comply was due to willful neglect. Before OCR imposes a penalty, it will notify the covered entity and provide the CE with an opportunity to provide written evidence of those circumstances that would reduce or bar a penalty. This evidence must be submitted to OCR within 30 days of receipt of the notice. In addition, if OCR states that it intends to impose a penalty, a covered entity has the right to request an administrative hearing to appeal the proposed penalty. If subject to criminal prosecution, the Department of Justice is responsible for criminal prosecutions under the privacy rule. An example of the possibility of criminal prosecution is a former East Texas hospital employee was sentenced for HIPAA violations in February of this year. The employee obtained protected health information with the intent to use it for personal gain, and he was indicted by a federal grand jury on March 26, 2014, and was sentenced to 18 months in federal prison. And again, in June of 2013, Kim Kardashian's records were inappropriately accessed at Cedars-Sinai Medical Center in Los Angeles, and as a result, 6 workers were fired for the internal breach. Then Cindy, I think you wanted to give a little shout out.
Yes, actually, I doubt very seriously for those of us on the call if Kim Kardashian is going to be stopping by our offices. So some of this may be hard to understand or appreciate. We found numerous examples of where people had actually looked at records without the intent for personal gain. One example I found was 4 months in prison, and the individual indicated they really didn't understand that they were even doing something wrong, and that's not an excuse. Some real-world examples that I've been faced with is just with various clients, perhaps working with a sports team. We have a group in Indiana that actually does healthcare for the Indianapolis Colts, being sure that no one was accessing their records. Another one as simple as this, we had a report where a neighbor had called in to one of our clients and they asked us to validate it because one of the employees was a neighbor of the patient, and they simply asked them, you know, why they were at the doctor and let them know that, and that was a privacy violation. They didn't really have a right to know that. So think about it when you're looking at this. This is really real world, and it's very, very serious, and it can happen to any one of us, not necessarily at the Kim Kardashian level, but it can happen just whenever you're looking at those records or your employees are looking at your records. Make sure they understand.
Great, thank you. So going off that, how does the privacy rule actually affect me? Well, if you work directly with patients or see, use, or share PHI, the HIPAA privacy rule affects you. As a part of your job, you must protect the privacy of a patient's PHI. Use, look at, or share a patient's PHI only if you need it to perform your job. Talk about a patient's PHI to others only if it is required to perform your job, and do it discreetly. Refrain from discussing PHI in public areas. This includes elevators, reception areas, or the cafeteria in a hospital or practice. Remember, HIPAA covers information given orally as well, and it should not be left out or left in the open, making it accessible to the public or other employees. Let's not forget the whole purpose of the privacy rule. And as long as you keep this in mind, all the detailed requirements will make sense. And that's to create standards for the use and disclosure of PHI and give individuals privacy rights to control and understand how their PHI is being used. So let's go ahead and switch gears to another big part of HIPAA, and that's the HIPAA security rule. The security standards for the protection of electronic protected health information, or as we call it, the HIPAA security rule, establishes a national set of security standards for protecting certain health information that is held or transferred in electronic form. The security rule operationalizes the protections contained in the privacy rule by addressing the technical and non-technical safeguards that covered entities must put in place to secure individuals' electronic protected health information. Prior to HIPAA, no generally accepted set of security standards or general requirements for protecting health information existed in the healthcare industry. At the same time, new technologies were evolving, and the healthcare industry began to move away from paper processes and rely more heavily on the use of electronic information systems to pay claims, answer eligibility questions, provide health information, and conduct a host of other administrative and clinically based functions. A major goal of the security rule is to protect the privacy of individuals' health information while allowing covered entities to adopt new technologies to improve the quality and efficiency of patient care. Given that the healthcare marketplace is diverse, the security rule is designed to be flexible and scalable, so a covered entity can implement policies, procedures, and technologies that are appropriate for the entity's particular size, organizational structure, and risk to consumers' ePHI. The rule specifies a series of administrative, technical, and physical security procedures for covered entities to use to assure the confidentiality, integrity, and availability of ePHI, which we'll get into after we answer the basic questions of who, what, and why. So who and what is covered under the HIPAA security rule? The security rule, like all the administrative simplification rules, applies to CEs and BAs. Specifically, the covered entity has certain responsibilities. If a covered entity knows of an activity or practice of the business associate that constitutes a breach or violation, the covered entity must take reasonable steps to cure the breach or end the violation. Violations include the failure to implement safeguards that reasonably and appropriately protect ePHI. Now moving on to the what. The security rule protects a subset of information covered by the privacy rule, which is all individually identifiable health information a covered entity creates, receives, maintains, or transmits in electronic form. The security rule calls this information electronic protected health information, or ePHI. The security rule does not apply to PHI transmitted orally or in writing. So the security rule applies to a smaller subset of information than the privacy rule does, specifically to electronic PHI. An ePHI is computer-based PHI that is used, created, stored, received, or transmitted by a CE using any type of electronic means. Think information in your EHR, patient billing information sent to a payer, digital images, and patient information sent to other providers. We know the who and what information the security rule covers, but let's get an idea of what the rule requires. The security rule requires covered entities to maintain reasonable and appropriate administrative, technical, and physical safeguards for protecting ePHI. Specifically, covered entities must ensure the confidentiality, integrity, and availability of all ePHI they create, receive, maintain, or transmit. Identify and protect against reasonably anticipated threats to the security or integrity of the information. Protect against reasonably anticipated impermissible uses or disclosures, and ensure compliance by their workforce. So specifically, how do we protect ePHI? To start, we need to ensure the confidentiality, integrity, and availability of information through safeguards. Confidentiality means information will not be disclosed to unauthorized individuals. Integrity refers to the condition of the information, ensuring it has not been altered or destroyed in an unauthorized manner, and data is accurately transferred. And availability, meaning the information is accessible and usable upon demand by an authorized user. Like I mentioned before, we protect this ePHI through 3 different types of safeguards. one of which is administrative. The security rule defines administrative safeguards as administrative actions, policies, and procedures to manage the selection, development, implementation, and maintenance of security measures to protect EPHI and to manage the conduct of the covered entity's workforce in relation to the protection of that information. The administrative safeguards comprise of over half of the HIPAA security requirements. As with all the standards in this rule, compliance with administrative safeguard standards will require an evaluation of the security controls already in place, an accurate and thorough risk analysis, and a series of documented solutions. There are standards which must be in place in order to be in compliance with each set of safeguards, and for administrative safeguards, they are security management, assigned security responsibility, workforce security, information access management, security awareness and training, security incident procedures, contingency plan, and evaluation. So let's just talk about the first one on this list, which is security management. Security management means implement policies and procedures to prevent, detect, and contain and correct security violations. The purpose of the standard is to establish the administrative processes and procedures that a covered entity will use to implement the security program in its environment. There are 4 implementation specifications in the security management process standard, and one of these is a security risk analysis, which we will talk more about next. So a security risk analysis. Does this sound familiar to anyone? Maybe ring a few bells with meaningful use requirements? Well, it's not just meaningful use that is requiring this analysis. The administrative safeguards provisions in the security rule require covered entities to perform a risk analysis. The risk analysis implementation specification requires CEs to conduct an accurate and thorough assessment of the potential risks and vulnerabilities to the confidentiality, integrity, and availability of electronic protected health information held by the covered entity. In general, a risk analysis can be viewed as the process of identifying potential security risks and determining the probability of occurrence and magnitude of those risks. So a risk analysis process includes, but is not limited to, the following activities. Evaluate the likelihood and impact of potential risk to EPHI. Implement appropriate security measures to address the risks identified in that risk analysis. Document the chosen security measures and, where required, the rationale for adopting those measures. And maintain continuous, reasonable, and appropriate security protections. Security risk analysis should be an ongoing process in which a covered entity regularly reviews its records to track access to EPHI and detect security incidents. It should periodically evaluate the effectiveness of security measures put in place and regularly reevaluate potential risks to EPHI. So there are numerous methods of performing risk analysis, and there's no single method or best practice that guarantees compliance with the security rule. But there are several elements a risk analysis must incorporate regardless of method employed, and these are what I've listed on the slide. So there's scope of analysis, data collection, identifying and documenting potential threats and vulnerabilities, assessing current security measures, determining the likelihood of threat occurrence, determining the potential impact of threat occurrence, determining a level of risk, and finally, finalize documentation. So the security rule requires the risk analysis to be documented, but does not require a specific format. The report should document procedures performed during the analysis, results of the analysis, and implementation plans with target completion dates for any security deficiencies discovered during the analysis. And finally, periodic review and updates to the risk assessment. The risk analysis process should be ongoing. I've said this many times now. In order for an entity to update and document its security measures as needed, which the rule requires, it should conduct continuous risk analysis to identify when updates are needed. Now, the security rule does not specify how frequently to perform a risk analysis as a part of a comprehensive risk management process. The frequency of performance will vary among covered entities. Some covered entities may perform these annually or as needed, depending on the circumstances of their environment. But conducting a risk analysis is the first step in identifying and implementing safeguards that comply with and carry out the standards and implementation specifications in the security rule. Therefore, a risk analysis is foundational and must be understood in detail. So the HHS provides a really nice summary of all the required and addressable implementation specifications for each set of safeguards. All of the standards and implementation specifications found in the Administrative Safeguards section refer to administrative functions, such as policy and procedures that must be in place for management and execution of security measures. These include performance of security management processes, assignment or delegation of security responsibility, training requirements, and evaluation and documentation of all decisions. Administrative safeguards are a special subset of the HIPAA privacy rule, HIPAA security rule, that focus on internal organization, policies, and procedures, and the maintenance of security measures that protect the health information. While physical safeguards protect your practice from physical theft or damage, and technical safeguards protect your practice from electronic threats, administrative safeguards create a strong security foundation. They keep your practice compliant and trained over time, and ensure that it is conscious of risks it faces, both internally and externally. So moving on to physical safeguards. The security rule defines physical safeguards as physical measures, policies, and procedures to protect a CE's electronic information systems and related buildings and equipment from natural and environmental hazards and unauthorized intrusion. The standards are another line of defense, adding to the security rule's administrative safeguards for protecting ePHI. When evaluating and implementing these standards, a covered entity must consider all physical access to ePHI. This may extend out of an actual office and could include workforce members' homes or other physical locations where they access ePHI. Standards of physical safeguards include facility access controls. The covered entity must limit physical access to its facilities while ensuring that authorized access is allowed. And workstation use and security and device and media controls. The covered entity must implement policies and procedures to specify proper use of and access to workstations and electronic media. A covered entity must also have in place policies and procedures regarding the transfer, removal, disposal, and reuse of electronic media to ensure appropriate protection of ePHI. So a big part of this is workstation security. When I say workstation, think of WOW as workstation on wheels, desktop computers, laptops, etc. that all contain ePHI. Some best practices and recommendations for workstation security are use antivirus software and a firewall. Encrypt and password protect portable devices. And de-identify PHI if it's on a portable media. Lock up laptops, offices, storage cabinets, and other portable media devices. Use automatic log-off. And back up data. Here we see this matrix again that outlines the standards and implementation specifics needed in order to be in compliance. Some things to point out is that you should have disaster controls, so located above ground in case of a flood, use a surge protector, or move workstations away from fire sprinklers. You should also have policies in place to destroy ePHI data when it's no longer needed, such as taking it to a designated place where hard drives can be destroyed and data disposed of safely. And the last safeguard we will cover is the technical safeguards. The security rule defines technical safeguards as the technology and the policy and procedures for its use that protect electronic protected health information and control access to it. The major standards found here are access control. A covered entity must implement technical policies and procedures that allow only authorized persons to access ePHI. Audit controls. A CE must implement hardware, software, and/or procedural mechanisms to record and examine access and other activity in information systems that contain or use ePHI. Integrity controls. A covered entity must implement policies and procedures to ensure that ePHI is not improperly altered or destroyed. Electronic measures must be put in place to confirm that ePHI has not been improperly altered or destroyed as well. And we have person authentication as well as transmission security. So a covered entity must implement technical security measures that guard against unauthorized access to ePHI that is being transmitted over an electronic network. Here we see this matrix again that I already kind of walked you through on the previous slide, but I will point out some examples of vulnerabilities identified by a security risk analysis in regards to technical safeguards. So some may be poor controls that allow access to EHR, audit logs that aren't being used enough, or electronic exchange of PHI is not encrypted. And some examples of mitigation strategies that you could use to be in compliance with these safeguards would be make sure secure user IDs, passwords, and role-based access is in place, conduct routine audits, and ensure data is encrypted during transmission and at rest as well. So HHS recognizes that covered entities range from the smallest provider to the largest multi-state health plan. Therefore, the security rule is flexible and scalable to allow covered entities to analyze their own needs and implement solutions appropriate for their specific environments. What is appropriate for a particular covered entity will depend on the nature of the covered entity's business, as well as the covered entity's size and resources. Therefore, when a CE is deciding which security measures to use, the rule does not dictate those measures, but requires the CE to consider its size, complexity, and capabilities, its technical, hardware, and software infrastructure, the cost of security measures, and the likelihood and possible impact of potential risk to ePHI. Covered entities must review and modify their security measures to continue protecting ePHI in a changing environment. So yes, we have these safeguards that must be addressed in order to be compliant with the security rule, but it's not a one-size-fits-all for any of these safeguards or the security risk analysis. That's why we have tried to provide you with the basic requirements and a guide to the bare minimum that is required, but each covered entity will have very specific security measures based on their practice. So some quick security reminders are password protect your computers and devices, back up your ePHI, keep offices and portable storage locked up and secured, run antivirus and anti-spyware, and encrypt your ePHI. So yes, there are technical, administrative, and physical safeguards in place for everyone, but the majority of the safeguards rely on the user, which is you. These security reminders would be ineffective without you as the user's participation. It's you who has to remember to lock the door, to log off the computer, to lock the cabinet where you're storing the laptops, etc. Security can't happen without your help. So in combination with the user's help, the administrative, physical, and technical safeguards, a covered entity must also adopt reasonable and appropriate policies and procedures to comply with the provisions of the security rule. This truly isn't anything new since all CEs must have been in compliance with this rule since 2005, but it should be a great refresher for everyone on what's required, because there's a lot. And there have been minor changes made to HIPAA through HITECH and the Omnibus rule, which we're going to cover next. So the Health Information Technology for Economic and Clinical Health Act, or the HITECH Act, is a part of the American Recovery and Reinvestment Act, or ARRA, of 2009. ARRA contains incentives related to healthcare information technology in general and contains specific incentives designed to accelerate the adoption of electronic health record systems for providers. So HIPAA changes under HITECH. I'm not going to cover all of these changes, but I will cover the major ones in the next few slides. But from this list, you can clearly see the legislative intent is to provide for enhanced enforcement of HIPAA. So this is where EHR certification standards started. The HITECH Act established ONC in law and provides the U.S. Department of Health and Human Services the authority to establish programs to improve healthcare quality, safety, and efficiency through the promotion of health IT, including EHRs and private and secure electronic health information exchange. So under HITECH, ONC was charged with establishing requirements for EHR certification, which in turn CMS uses for meaningful use in other health IT-related programs. It also changes accounting of disclosures a little bit. If you recall, this changed. You never had to include your disclosures for TPO, or treatment, payment, and operations, and now you do. It enhances individual access. So individuals now have the right to receive an electronic copy of their personal health information. This is just making a clarification that providers were only providing a paper copy at previous times. And then we have business associates. So here's one that takes on a little more weight and importance. The HIPAA privacy and security rules and penalties now apply directly to business associates as though they were healthcare organizations. Previously, the rule only applied to covered entities, and privacy and security requirements were imposed on business associates via contractual agreements with covered entities. Now the rule applies to any organization that has access to protected health information. The bottom line here is that business associates and providers will share more joint responsibilities than they have previously. So the HITECH Act now imposes data breach notification requirements for unauthorized uses and disclosures of unsecured PHI. Under the HITECH Act, unsecured PHI essentially means unencrypted PHI. In general, the Act requires that patients be notified of any unsecured breach. If a breach impacts 500 patients or more, then HHS must also be notified. Notification will trigger posting the breaching entity's name on HHS website, and under certain conditions, local media will also need to be notified. So on this slide, I've listed the major provisions of the breach notification rule. So we have the 60 days notice, and that basically means that covered entities and business associates must notify individuals within 60 days if their PHI is breached, and they also have to notify the Department of Health and Human Services and the local news media if it involves more than 500 people. An annual report. This basically means CEs have to maintain a log of all data security breaches annually and submit it to HHS. It specifies who reports to whom. So if business associates are experiencing a breach, they let their covered entity know, and then the covered entity notifies individuals. It defines a breach. It has a snail mail requirement, and that actually just says that a healthcare organization would have to send out first-class mail to any patients who might have been affected by a breach, and if 10 of those are sent back, then they have to notify the media or post on their website they had a breach. It also outlines some important exceptions. And then lastly, it instituted a harm threshold, and that would dictate when an organization has to notify individuals of a breach. Under this provision, organizations must conduct a risk assessment to determine if there's a significant risk of harm to the individual as a result of the impermissible use and disclosure. That means federal regulators are largely leaving it up to healthcare organizations to determine if they need to give notification. This harm threshold has actually been removed by the HIPAA Omnibus rule, which we're going to go over in just a few slides. This breach notification rule can seem very complicated, so with the help of HHS resources, we've created this decision tree to decide if you need to report a breach. So you can start at the top, ask yourself questions all the way down, and figure out if you need to report it. The HITECH Act also implements tougher penalties. So you can see from this chart here, it's a tiered chart. They changed this, and it goes all the way up to 1.5 million annually. And this is separate from any criminal penalties that may apply. And finally, what most of you may be interested in or concerned about is more audits. Although healthcare organizations can determine on their own whether a breach should be reported, HITECH provides funding for periodic audits by federal regulators of both healthcare organizations and their business associates to ensure they are, in fact, complying with all privacy and security rules. OCR uses several mechanisms to oversee these covered entities' compliance and the privacy standards. It may investigate covered entities in response to complaints, tips, or media reports. OCR may also proactively conduct audits of covered entities to assess their compliance efforts. The HITECH Act required OCR to provide such audits effective February of 2010. And the second phase of these audits actually begin in 2016, which we will talk about after we cover the minor changes made by the most recent update to HIPAA, the HIPAA Omnibus rule. So I'm not going to cover all the changes, but I will try and cover the big ones. On January 17, 2013, the Department of Health and Human Services, OCR, released the Omnibus rule, amending the HIPAA privacy, security, breach notification, and enforcement rules. These amendments implement and expand the requirements of the HITECH Act, and compliance was required with respect to most provisions no later than September 23rd of 2013. So before we get into the big changes, two quick definition changes that took place were the definition of PHI and that basically was expanded to cover information on those who have been deceased for 50 years. And the definition of workforce was expanded to make sure that the term included employees, volunteers, trainees, and other person whose conduct is under the direct control of a business associate. So the big changes here. Notably, the Omnibus rule broadens the scope of the new definition of business associate. It now includes any subcontractor, no matter how far removed from the original contractor, is considered a HIPAA business associate if it handles PHI. So this also applies the HIPAA security rule standards and implementation specifications and a certain privacy rule provisions directly to business associates. This means all of those physical, administrative, and technical safeguards are now required for BAs as well. Another sweeping change produced by the Omnibus rule affects breach notification framework. So the harm threshold that imposed a notification requirement only where there was a significant risk of harm to an individual was replaced by having a covered entity or BA demonstrate there is a low probability that the PHI has been compromised based on a risk assessment. So you have to perform a small risk assessment on the breach, and now that will determine if you need to notify the patients. The Omnibus rule also enhances the rights of individuals to restrict disclosures of their PHI and provides them with expanded access to electronic health records. And finally, the Omnibus rule requires a number of changes to the Notice of Privacy Practices published by covered entities. So this is updating those forms that you need to have patients sign. So NPPs must now include a description of the types of uses and disclosures that require an authorization. It must state the other uses and disclosures not described in the notice will be made only with the individual's written authorization. It needs to include a statement that the covered entity is required by law to notify affected individuals following a breach of unsecured PHI. But it does say the statement may be general in nature, and it's not required to provide detailed information about what constitutes a breach or what notices are required. So I mentioned earlier that HITECH had given the OCR the authority to conduct audits to make sure providers are HIPAA compliant. Now, this isn't the first time we've heard the word audit. We've just recently held a webinar on meaningful use audits, but I don't want to get these confused. They're different audits enforced by different entities and look for much different things. For instance, I want to point out that MU audits are only looking at your EHR, while OCR is a HIPAA audit, so it's looking at PHI in all of your devices. So the OCR Hipaa Audit Program analyzes processes, controls, and policies. It's actually established a comprehensive audit protocol, and you can see this on your screen. It addresses the privacy rule, security rule, and breach notification. So the Office of Civil Rights is conducting these audits to make sure providers are HIPAA compliant. This initiative was broken down into 2 phases, which I talked about. And if you fail an OCR Hipaa audit, you may be subject to steep fines. And these fines are based on the damage done and how many lives are affected. So these phase 2 audits that are important to us right now, since they're happening and a new wave is about to begin next year, focus on covered entities and their BAs, risk analysis especially, risk management, facility access control, breach notification, encryption and decryption requirements, etc. So the audit process for phase 2 is laid out in front of you, showing you the distribution of CEs and BAs that will be selected, as well as what to expect if you are selected. You're going to have 2 weeks to respond, and it will most likely be a desk audit, so no one will likely to be coming on site, but failure to respond may lead to a compliance review, which I don't think is anything any of us want to happen. So we provided some of these best practices according to NextGen on how to prepare for a HIPAA audit. We are going to be sending out the slide deck, so I won't bore you guys and read through all of these, but this is also what NextGen has prescribed as well. So I'm actually going to go ahead and turn it over to Cindy so she can walk you through this last section on how to avoid a health data breach.
Okay, thank you. Basically, as we start talking about health data breaches, I want to take you through some of the numbers that are associated with a healthcare data breach. If you kind of look at what's been happening, on December 2nd, 2015, a report was released with what I consider shocking statistics. $6 billion is the cost associated with cyber attacks attributed specifically to healthcare. 94% of healthcare organizations have indicated they've had some type of breach. Healthcare information is about 10 times more valuable than any other data on the black market. And it's not something I don't think a lot of people understand or know, but they are looking for your data. So there is tremendous incentive for these breaches to take place. 68% of breaches that occurred have been in healthcare. These numbers are pretty upsetting, and they have increased dramatically over the past several years. We want to talk about some real-world breaches. On December 14, 2015, the University of Washington Medicine agreed to settle charges that it violated the Hipaa security rule. The settlement was $750,000 and has shifted the OCR focus on organization-wide security risk analysis. The OCR began an investigation after a breach was reported where the PHI of 90,000 individuals was accessed due to an employee's downloading a malicious email attachment. Wasn't intentional, happened, and this is the result of it. Other examples of breaches that we were able to find is Excelis Blue Cross Blue Shield announced in September that it was the victim of a sophisticated attack. I think everybody heard about this one. This compromised the identifiable information of more than 10 million members, making this the third largest healthcare breach in 2015. Premier Blue Cross admitted in March that it had experienced a cyber attack affecting up to 11 million members. Hackers had accessed the names, birth dates, social security numbers, member identification numbers, and bank account information. And then, of course, Anthem, another one that we all heard about. Hackers swiped social security numbers, addresses, dates of birth, income data, and other personal data of over 80 million people. Now, granted, all of these are going to be very large targets, and you might say that, well, no one's interested in mine. Also think about the security that they must have had in place and still were unable to keep these out. It's very important to pay attention to what you're doing and make sure that you understand it. So the best practices to prevent a breach: conduct an annual Hipaa security risk analysis. Encrypt your data at rest. Many of you on the call may be hosted. That's probably being taken care of by your company. However, be sure you ask the questions. Conduct more frequent vulnerability assessments and penetration testing. Invest in the security awareness of your workforce. We at ITENIV have to take a course every 2 years in full Hipaa, both the security rule and the privacy rule, and we have to, all of our employees must pass it, and it must be 100%, and that's just something we require. Engage with your business associates. If you don't have one, make sure that you have someone that you can help you with this and actually evaluate whether or not you are doing this properly. Are you uncertain of where your practice stands? Let ITENIV help. By assessing your current readiness, we can do that for you. We have a lot of different levels. Maybe you just want a second set of eyes. We can assess where you're at. We can provide recommendations based on that assessment. And in the event that you need our help, we can also help you implement new processes and procedures, not just for your IT, but also for your workforce and how to make sure everyone understands the importance of this. So right now, I know we went a little over and we were planning on it. We're going to break it out for some questions. But one thing I want to ask is, so we're going to do a little joke. So knock, knock. Who's there? Hipaa. Hipaa who? And I'm sorry, I can't tell you that. May sound really corny and hokey. We laughed about it. We thought we weren't going to put it in because it is pretty silly. With that said, it's really that simple. You never know what or how someone's going to be trying to get the data, and be cautious of anything that you're talking about, releasing, or looking for the world to do. So any questions?
Hi, Cindy and Lindsay. Thanks so much for that presentation. Very thorough. I want to remind people that you can ask questions in the question control panel of the webinar control panel. So we'll give you a couple minutes to start typing those, and I'll start with the ones that we have. What's the difference between consent and authorization under the privacy rule?
I can grab that one, Cindy. So I know we didn't mention a consent even in this presentation because the privacy rule does not require a covered entity to obtain patient consent. So what we see is covered entities do actually have consent for treatment or payment or operations, and if they do that, they have complete discretion over how they want to design the whole process and how it best suits their needs. But an authorization is actually required by the privacy rule for uses and disclosures of that PHI. So a consent is seen as kind of insufficient compared to an authorization because of the requirements laid out by HIPAA and what must be included in an authorization. So I know I went over it pretty fast, but an authorization must have specific elements. It needs to have a description of the PHI being used or disclosed, the person who's authorizing the disclosure, the person who's going to receive that information, as well as an expiration date. Whereas a consent you can design on your own, and that's for your own practices needs.
Thank you, Lindsay. Next question. Is encryption required on data at rest?
I'll grab that one, Lindsay. Yes, it is required on data at rest. There's a lot of confusion about that and what that exactly means. And the concept behind it is, I've got my servers in-house, they're there, and why would I need to have that encrypted? Well, the bottom line is someone could come in and they could take the servers. They could break in and pull the servers out of your entity, very much like they crash into jewelry stores these days and pull all the jewelry out. It is required to have encryption on your data at rest.
And just to throw in, this isn't just a HIPAA requirement as well. This was just added to the modified stage 2 meaningful use rule that was just released as well. So that needs to be
absolutely
in place.
Thank you for that. Yep. So it's now a requirement on both sides of the house. Again, as a reminder, they are different. The meaningful use is typically a little less stringent than the HITECH requirements. With that said, they're catching up. And as Lindsay said, that was added to the meaningful use stage 2.
Thanks, ladies. Next question. Is a business associate contract required with organizations where an inadvertent contact with protected health information may result, like a janitor?
I can grab that one. So a business associate contract not required with people or various organizations whose functions or services don't involve PHI. So generally, janitor services that come and clean offices and facilities, that wouldn't apply to them because they aren't actually involving or using or disclosing PHI. And any disclosure of PHI that occurs with the performance of their duties, I'm thinking along the lines of like emptying trash cans or maybe someone's computer was left on. It's limited, and it's not, and there's no way to reasonably prevent it. So this type of disclosure would actually fall under the incidental permitted uses and disclosures. So if you remember when I went over that example of writing a patient's name on the whiteboard at a nurse's station, that would fall under the same kind of permitted use and disclosure where you don't need any authorization from a patient or a business associate agreement.
Thanks, Lindsay. And I want to remind everybody to follow us on social media. If you have any questions, you can always ask us on there. Every Tuesday, we post tech tips. We do announcements for upcoming webinars. You can always ask questions, and we'll answer them there. Next question. Are there rules for email?
I'll grab that one because I've had quite a bit of experience with that. Yes, there are very specific rules for email, and each of you should have, if you are using email as any form of patient communication, whether it's internal to your organization, whether it's external to your organization, you should have an encrypted email system, some form of system that encrypts the emails and makes sure that they're not going there. And keep in mind that with text messages as well. There are a lot of things out there that you can use, and there are a lot of services you can. We can certainly give you some advice on those. It's very important to make sure not only your team members understand this, your physicians. We all know how challenging it can be sometimes with physicians and getting them to use the email that your company is providing. I still get emails many times from Gmail and Yahoo.com and all kinds of things from physicians, and it's really, really critical to make sure that they understand that because that is counted, and that's a very common area for breaches.
Great, thank you, Cindy. I wanted to tell everybody that we do have a blog going. If you haven't checked out our blog lately, take a look. Lindsay recently wrote a pretty cool one on millennials, and pretty soon here Cindy's going to be writing one on the baby boomers' outlook on healthcare. So check those out on our website. Let's see, it looks like we only have one more question, so if you have any more, type them in and we'll answer them. Otherwise, we'll finish with this one. Our providers often take their laptops home. Is that a concern?
It's not a concern at all if those laptops are encrypted or if they are not using the laptops as a catalyst for storing data. For example, if the laptop is only used in terms of, say, connecting via a VPN and that there's nothing ever downloaded, that's really hard to manage. So my recommendation would be is make sure those laptops are encrypted. And I can tell you a story from my tenant's perspective to not even understand. About 5 years ago, well, before this really got as difficult and challenging as it is, but the rule was still the rule 5 years ago. It was just not as stringent. We always encrypted our laptops. However, we're flying all about, we're on planes, and one of our employees actually left their laptop on the plane. So happened that particular laptop had been in repair, and she had a temporary laptop, so they had moved her data. It was not encrypted, and there was PHI on it. The good news is we got the laptop back. We had a security test ran on it to make sure that it had not been breached, and there are ways that you can do that, and trust me, that's never happened to Attentive again, because we were all extremely nervous, and so was the employee. It involved crying at the airport, going through bins of lost items. We were able to get it back, and nothing was violated. It's very serious, so make sure those laptops are encrypted. That's the only real safe way to do it.
Okay.
And going off that, just quickly, sorry, I just want to add something in. It's important for the security rule with those safeguards. That HITECH and that Omnibus rule extends those safeguards to any portable media you have. So think of physical safeguards of when you're taking that laptop home. Is it stored somewhere above ground where a flood wouldn't get it, or locked up behind closed doors, along those lines too? So keep those safeguards in mind as well.
Yeah, if you're out shopping for the Christmas holidays or any other holidays that you may be doing, don't leave them in your back seat. Make sure you do that, because that's something else that could be a real challenge, particularly if you haven't had time to encrypt them. Make sure that you have everything in place, and understand that you are walking around with very protected data, and it's a very high responsibility. And again, educate, because I'm sure everyone on the call has an interest, or you wouldn't be on the call. Make sure this extends to all of your team members, your employees, and your providers.
Hey, Cindy, I'm pretty sure that everybody knows the answer to this, but what about cell phones?
Absolutely. Again, cell phones are fine if you're not downloading data. We have cell phones. At a minimum, make sure you have your screens locked. Make sure if you got an iPhone, make sure you have it passworded. Make sure you have the location devices on, so that if it becomes missing, you can erase the data. And once again, use it for what is the purpose. It's phone, it's text messaging, however you use it. Make sure, even with your email, that you're not downloading that data, and you have at least the minimum safekeeping in place. If you are using them for more than just a vehicle to access, your webmail or something where you're not really storing the data physically on the phone, make sure that you enlist other security agencies. There are programs and apps and things that you can get that can enhance the security. As I said, we at Attentive all use our cell phones constantly. We access our webmail, and our requirements are: make sure that you have your screen locking device on, lock it after a period of time, and make sure that you have every phone is different. I'm an iPhone user, so you have your Locate My iPhone turned on, and then if it does become missing, you have the ability to wipe the data off of it. And at a minimum, make sure that everyone's doing that.
Okay, great. Well, thank you, Cindy and Lindsay, and thank you everybody who joined us today. If you have any questions, please don't hesitate to reach out to us. That's why we're here. I'll be sending an email later this week with the recording and PDF slides, so you can either reply to that with questions, and I'll get them to the right people, or with Cindy and Lindsay's information that you just saw up there. So thank you very much.
And on a separate note,
yeah,
happy holidays, and we look forward to seeing all of you on the webinars next year.